In this, I am Pranav, belong to Faculty of Law and Governance. In this video, we are going to learn about fundamentals of Hart's concept of a legal system. Now, H.L.A. Hart views the concept of a legal system from the perspective of a positivist. He is the one that I have told you in the previous sessions that he is the one who used the term legal positivist. Well, legal institutions and other phenomena related to the law must be studied exactly as they are. Law is, in general, to be considered apart from morality and is to be subjected to a systematic analysis. Law as a social phenomenon, which is how H.L.A. Hart views it, involves for those who wish to study it. Reference to the characteristics of human condition, that is the social fact. Now, in the concept of law, which got published in 1961, in which Hart articulates his concept of the essential features of a legal system. He lists those characteristics as human vulnerability, the characteristics of human condition, human vulnerability. Each one of us can be subjected to undesired physical violence. Approximate equality, making necessary mutual forbearance and compromise. Limited altruism, tendency to aggression which required control. Limited resources, we need food, shelter, clothing, all of which are in limited supply. And limited understanding and strength of will. Our understanding of long-term interests cannot be taken for granted. There arises therefore within society a need for rules to protect persons, property, and promises. It is where law is very important. It is the problem of rules, their constituent features, and their internal relationship, which dominates Hart's interpretation of the essence of legal system. Now, Hart's view may be summarized like this. Now, if a legal system is to obtain within a community, two circumstances must coexist. First, there must be a variety of valid obligation rules, which are generally obeyed by the bulk of members of society. Secondly, the officials within that society must accept additionally certain rules of change, adjudication, and responsibility. Now, these terminologies must be examined. The term rule is not to be viewed in austin terms, namely as a command. Now, within a society, there are social habits and social rules. Now, we will see to them what they actually mean. Now, social habits and social rules. Social habits which are not conterminous with rules. Social habits may be exemplified by members of a group who visit the theatre every Friday evening. Failure by some members to attend the theatre on Friday evenings will not be perceived as a fault. I go to temple every evening. One day I did not go to the temple. I cannot be held liable for not going temple in a strict legal sense. And they do not considered as breaking of any rules, breaking of any law. Now, social rules are more significant. Where they are broken, criticism will result because a fault is thought to have been committed. A breach becomes a matter of general concern. So, if I have to pay tax on a regular basis and I failed to pay that tax, a general criticism will come my way, and my failure to pay that tax will result in a social concern. Now, existence of a social rule involves its acceptance by social group as a whole. Awareness of a rule and support for its significance and acceptance within the group are termed by Hart the internal aspects of that rule. So, what is the internal aspects of rule? Awareness of the rule, support for its significance, and acceptance within the rule. These are the internal aspects of the rule. What are the external aspects of a rule? The external aspects of a rule refer to the fact that an observer outside the group could be aware of its existence because particular patterns of behavior appear to be followed and regulation may be discerned. Now, H.L.A. Hart gives a very interesting example. He says two players are playing chess and I am sitting in audience. I am outside of that group. So whatever the rules are there, which I am perceiving it as externally, but I can sense what all rules, what all guidelines that these players are following. Hence, social rules are Hart's classification are of two kinds: mere social conventions and rule constituting obligations. Social conventions refers to rules of correct behavior in a place of public worship. For example, the rules constituting obligation refers to conformity, which is considered essential in everyday society's life. Now, Hart state rules are conceived and spoken of as imposing obligation when the general demand for the conformity is insistent and social pressure brought to bear upon those who deviate or threaten to deviate is great. Now, the rules relating to obligation impinge on the idea of moral duties and are what we understand by law. Now, moral duties constitute a significant and important proportion of a society's moral code. Some may have originated in ancient customs. The breach of a moral obligation does not itself usually result in the punishment of the offender. But nevertheless, there are often intense pressures to carry out these duties. Now, Hart argues a small community closely knit by common sentiment and belief and placed in a stable environment might be able to live with a set of rules approximating to the primary rules of obligation. But this would not be possible in a large community. Because of the very nature of the primary rules, thus doubts might arise as to what are the rules or as to the basis on which those doubts are to be settled. The problem would be one of uncertainty. Further, the static nature of primary rules might create a further problem. Deliberate adaptation to new circumstances might be difficult. A third defect would be inefficiency of the diffuse social pressures by which the rules are maintained. There would be no specialized official agency empowered to ascertain whether or not a rule had been broken. Primary rules would not in themselves suffice as building blocks for the construction of a legal system. Something more is necessary. And this something more is secondary rules. Now, these rules would be parasitic on the primary rules. And these rules are the enabling rules. And these rules are the rules about rules. They will provide that members of the community may, by performing action or saying things, introduce new rules of the primary sort, modify old rules, control the operation of primary rules. Hence, sometimes these rules are also called rules for officers, hence enabling. Now, the unity of primary and secondary rules constitute Hart's conception of law. The defect of uncertainty, that is, lack of authoritative procedures for settling dispute, would be cleared out by rule of recognition. The defect of static rules would be cleared out by rules of change. The defects of inefficiency will be cleared out by rule of adjudication. Now, primary and secondary rules constitute the law, which is the essence of legal system. Now, Hart give a very unique answer. What is meant precisely when it is said that a legal system exists? Now, two basic conditions must be satisfied before it can be said with accuracy that a legal system exists. First, rules, and in particular rule of recognition, must be obeyed. Secondly, the secondary rules must be accepted by the community's officials as common public standards. Now, the first of these sorts involves a general obedience in practice by the mass of citizens to the community rules, which have a validity derived from the rule of recognition. Now, the hard second condition refers to the relationship of community's officials to the secondary rules. Now, Hart suggests that to assert that a legal system exists is to make a Janus phase statement, which looks both towards obedience by ordinary citizen, which of course will include an element of acceptance of rules, and to the acceptance by the community's officials of secondary rules as common standards of official behavior. In accepting these common standards, the official will show a critical and reflective attitude to the appraisal of their own and one another's performance. The internalization of the rules they profess to follow acquires unusual significance as partial indica of the real existence of a legal system. Now, with this, we come to the end of Hart's legal system. Now, further, we move to various other legal positivists. Some of them might be system of coercion as to what is Kelson's theory of laws, Kelson's grand norm, and what else. So we will discuss this in later sessions. Till then, thank you.